Hello, everyone, and thank you so much for joining us here on Immigration Talk Show. Welcome, dear friends, for another interesting webinar that's lined up. And let me tell you that it's going to be very, very insightful. So stick with us because it's going to go on for about an hour, and we're going to have a very amazing immigration attorney join us from Dallas, Texas. And I'll tell you who is it going to be. But before that, here's the important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, I hope you keep that in mind. And another good news is that you can also join us here on this webinar by commenting wherever you're watching. We are live right now on YouTube and also on LinkedIn, Facebook, and on X. And do check us out. We are also available on Instagram, and our handle is at Immigration Talk Show. And just on X, that is Twitter, we are at Immi Talk Show. So check us out, and anything immigration related, especially with US immigration, please feel free to tag us. And our tag is at Immi Talk Show. So, welcome once again, friends. I'm Nipasa, and I'm going to be your host for this session that's lined up. And our guest for today is going to be a very familiar face, none other than attorney Chand Parvataneni from Dallas, Texas, SPB law firm. So, I think, yes, without further ado, please help me welcome him back to the show. Hi, Chand. I hope you're doing great this week as well. It's been a while. I'm sure it must be very, very busy for you. Oh, I think there could be some problem, but no worries, friends. What I want to say is subscribe to us if you haven't as yet. Subscribe to our channel. So our handle is at Immigration Talk Show, and today we are going to be discussing on how long does perm processing take, and understanding the steps and delays. I know we are all sort of worried with all the updates every day. Every day is becoming a new day, so much happening, right, with relation to immigration, and everything is being affected, whether it's the economy you talk about, or um, you talk about even um, everything for that matter. And I'm so happy that Chand is back. So yes, without further ado, help me welcome attorney Chand Parvataneni from SPB law firm. Hi, Chand.
Hello, Nipasa. How are you? And thank you for this session today. Hopefully, we'll have a very good session talking about PERM and how it is so connected with the people on H1B and other work visas in the United States.
Absolutely. I'm excited, and every day has been a new day, and there's been so much updates. And immigration is really affecting everything, the market, the economy, and everything it touches, I think. So it's very, very interesting. Every day is a new day with new updates, especially with this our President Trump's administration. So it's going to be exciting to get to know more about what perm really is, especially today, right? It has changed, I think. So, Chand, if you can actually tell us a little bit also.
Sure. So PERM, it's also called, colloquially, it's also called as labor certification. And PERM or labor certification. So this is like the first step in getting a green card, in getting a green card through employment-based process. And most of the people on work visas, typically on H1Bs, they get the green card through their employer sponsoring them for their green card. And the way this happens is through the employer either using the category called EB2 or a category called EB3. And this PERM, this is administered by US Department of Labor. It's not by USCIS. It's not through Department of Homeland Security. It is through Department of Labor. And the reason Department of Labor is involved in this step is because the government wants DOL to certify that a particular position, the skill set for that particular position, labor for that particular position, it is not available in United States. So DOL is very highly involved in this process, and their goal is to make sure that there is a reason why you need to hire a foreign worker, and the reason for that is that that kind of a skill set is not available in the United States, and that is the reason why you need to bring in this foreign worker, sponsor the green card, and doing so it is not negatively going to impact the job opportunities, wages, or working conditions of United States workers. So the big thing is this is a process where DOL is heavily involved. They administer this process, and DOL has to certify this particular application, and that is the first step before somebody can even get a green card. And if we talk about what are the steps in terms of the perm processing, so the first steps are the employer. So the employer has to really define what exactly is the job, what exactly is the job title, what exactly are the duties. They also have to define what are the minimum requirements. And when we talk about requirements, it is minimum education, minimum experience, maybe some special requirements such as maybe some tools such as, like, say for example, DevOps or Java programming language or something else. So these are the kind of requirements that the employer actually has to define. And the way the employer defines these requirements is they have to look at their general requirements, the industry standards, and then come up with this job requirement. And then they need to have a need to hire somebody permanently in a full-time position. So the minute they come up with this job description, come up with the requirements, and understand that there is a requirement to hire somebody in a permanent capacity, not in a non-immigrant capacity, but a permanent green card, for example, in that capacity, that is the time they define this job role, and then they give this description to DOL. And this is a step called prevailing wage determination. So what prevailing wage determination is also a very important step. One of the first steps in the perm process is the employer has to file something called prevailing wage determination through a form 9141. And this is where Department of Labor initially looks at the job description. They see what exactly the job is. They see what are the requirements. They see the travel requirements. They see the relocation requirements. And as a whole, they look at the job duties, look at the requirement, and they do something called a prevailing wage determination. All that means is Department of Labor is going to come back and say, yes, if you have this kind of a job requirement, this is the minimum wage you have to offer. So that minimum wage that needs to be offered is what is being determined in this first step. The step number one, called the prevailing wage determination step, is a step where DOL comes back and tells the employer, this is the minimum salary that you have to pay if you want to sponsor somebody for a green card. If the employer agrees, they go to the next step. So that is the first step. And at this point of time, what the employer is doing is the prevailing wage is determined. Now they have to do something called a recruitment step. So this recruitment step is more of a US labor market test. So this entire perm process is all about finding out if there is anybody in United States who is qualified for the job, who's minimally qualified for the job. And there is a big administrative process that has to be followed. And the way it is done is you have to conduct something called recruitment. And what that means is you have to put advertisements, and there are mandatory advertisements that the employer has to advertise. So for example, in the local newspaper, they have to put 2 consecutive newspaper advertisements. In the local state workforce agency, they have to do a posting, a job order posting. So it is the way for the company to go and advertise their job and ask for people to apply. And that is where they're doing a labor market test to see if somebody is even minimally qualified. Not only these 2 advertisements, they have a bunch of other advertisements that they are supposed to do. They are supposed to do some internal job postings. They're also supposed to use one of the other means to recruit, such as company websites, job fairs, online job postings, maybe radio advertisements. So they have a choice on what they want to use. And they have to conduct all these recruitment steps to ensure that they're actually going into the local workforce. They're letting people know that they have a job opening. They're letting local people apply for this job. And this whole process takes some time, but the goal is that the company is actually looking for people who are qualified locally. So maybe US citizens, maybe green card holders. So locally, what they're doing is they're doing this recruitment step to see if somebody is even qualified. And at the end of this entire process, they come back and look at what has happened. They look at all the resumes that they've received. They have to go through them. They have to probably interview a couple of applicants who are minimally qualified, and then see what's going on. Only if the employer determines, after following all the steps, all the regulatory steps, that there is nobody that is qualified for that particular position, maybe because the US worker does not have the right education, maybe they don't have the right skill set. So they have to thoroughly document all these steps. Only if no minimally qualified US worker is available or willing or able to take this job in that fashion, at that point of time, the company is eligible to file something called the PERM. So even to file this PERM, all this entire process, all this complex process has to be undertaken by the employer. So at the last, they have determined that there is nobody qualified in the US labor market. At that point of time, the company files something called ETA Form 9089. This is the actual PERM application. And again, this is again filed with Department of Labor. So again, you go through the process, you document all your steps, you document all the dates, and then you go back to DOL, you submit this Form 9089, called the PERM application. It is done on a website called flag.dol.gov. That is the website this PERM application is filed. And then once the PERM is filed, the processing starts by Department of Labor. At that point of time, Department of Labor reviews the PERM. If they like it, they certify it. If they have a problem, they might call for an audit. And this entire process again takes a long time. And that is what is PERM. And once the PERM is certified, that is when the employer can go back to USCIS. So this is the first step. And PERM is a mandatory step for any employer who's going through the EB2 process or EB3 process to sponsor their employees to get a green card.
It's very interesting and very, very important. So, for friends out there, PERM is what you really need to keep in mind. And of course, each and every step is important. It may be complicated and you may have some confusion. So, what I always suggest is, always consult an immigration attorney, so that you are guided and are on the right path. So, in fact, you can also contact attorney Chand Parvatineni from Dallas, Texas, SPP law firm. So, yes, you can do so by checking out this link here on the screen and go check it out. So, yes. And also, friends, you can join us on call, by the way, in case you have questions you want to ask right now. What you can do is call us on this number 425 That's the number. And when they ask for the access code, you dial in 988 888. So, yes, that's it. And now, also quickly, I would say hi to Robinson. Thank you so much for joining us here on YouTube. And Robinson actually has a question, which I think, quickly take it up, which is when it comes to the priority date for the green card application, how does the PERM approval tie into that? And is there any way to predict when my priority date will become current after PERM approval?
So the day the employer files the PERM, so before even filing the PERM, the employer has to file the prevailing wage determination process. They have to do the recruiting and all those steps. That doesn't count. The day the Form 9089 actually gets submitted to Department of Labor, that is the date which is called as the priority date. So the day the 9089 application is submitted, it will be on the 9089 form. That is your priority date. And then what you do is you go and look at something called the visa bulletin. So this is released by Department of State every month. And if you go to the Department of State's visa bulletin, right now the May bulletin is out there. So if you look at the May bulletin, so under each category, EB2, EB3, you will see the current priority date. So what you would do is you would simply go and if you're from India, they have a date. If you're from China, they have a date. And for the rest of the world, they call it as rest of the world. And for the rest of the world, they have another date. So what you do is you go and check the corresponding date. It will give you an idea about what kind of priority dates are currently getting processed. So for example, your date is in 2013 and you're from India. Country of birth is India. Right now, those priority dates are getting processed. So what that means is anybody from India whose perm, the perm 9089, was filed in the month in the year 2013. So those people's priority dates are current right now, because that is what the visa bulletin is currently saying, and those people are eligible to get a green card right now. So based on your country of birth, if you look at the visa bulletin, you will see the priority dates. And in your case, the priority date would be the date your employer has actually submitted this 9089 form to Department of Labor. And in terms of prediction, the visa bulletins are the best way to predict your when your priority date would get current. So if you kind of see the last couple of months, you'll kind of get an idea on what's happening. And then in the visa bulletin, you have two charts. There is a chart one, the final action chart, and then you have a date of filing chart. So final action chart is what is currently going on. The date of filing chart is what even the Department of State is predicting would happen in the next 1 year. So normally you look at these charts, you see their predictions. Department of State also gives their predictions, and based on those, you get an idea on when your priority date might get current.
All right. Thank you so much, Chand, for taking this up for Robinson. Robinson, thank you for your very interesting question. It added more to our show because, we could touch up on these things you really needed to know. So thank you to you too. And if you haven't as yet subscribed to us, subscribe now and hit that bell icon so that whenever, we have these discussions, you are notified. Our handle is @Immigration Talk Show. All right, Chand, we have more questions, so I think we will go on to our next one, and that is what are the current timelines for PERM?
The current timelines are extremely bad, and right now Department of Labor is experiencing significant delays. So I mean, compared to what we saw about 5-6 years back, I think the last 2 years things are really bad. And uh, and there are a lot of reasons on what's going on. So the very first step, which is the prevailing wage determination step, the current timelines are taking at least 6 months, approximately 6 months. And the prevailing wage determination, because that is taking a very long time, it is slowing the entire process. Then the very next step, which is after recruiting, because recruiting is again the same. Recruiting takes about 30 days. You start the advertisements in about 30 days, you can get everything completed. Once the recruiting is done, you again have to wait for another 30 days. There is something called cooling off period. So for the 30 days cooling off period, you cannot really do anything. So you have to allocate about 60 days for recruiting once the prevailing wage is done. So you're already looking at about 7 to 8 months just to even file the perm from the day you decide to sponsor somebody. Now, once the perm is filed, unfortunately, things are looking extremely bad. Right now, it is taking at least 16 to 17 months. That is what we are seeing. The cases that got filed in December 2023, we are seeing the firms get certified right now. This month, that is what I'm seeing. The December cases are getting certified right now. So you're actually looking at about 16 to 17 months from the date your employer actually filed the PERM 9089. And again, this is assuming there is no audit. If there is an audit, you can again expect another additional 6 months or so, which would again drastically kind of slow down the entire process. And the reason for this is because things have changed about 2 years back. We used to use a system called PLC. PLC was a website that DOL had. We used to use that website to file the perms. And 2 years back, DOL changed their process a little bit. They now use a system called flag.dol.gov. So the perms are processed in flag. And at that time, they made some technical changes. So it's not really the change in process. It is just the change in the application, the way they were asking questions, the way it is processed. They changed a few things. And once they moved to this new system and the process got changed, that is when we really started seeing a lot of delays, which is where we are now seeing 16 to 17 months. And that is like one of the foremost things. And again, in terms of the timelines, if you look at this entire process, if your employer says, let's get the perm start, let's get the sponsorship started, sponsorship to file the perm, you can easily expect at least 20 to 24 months to get the entire process done. And that's assuming things are done like very quickly. The company is applying for prevailing wage right away. The company is doing the recruiting steps right away. And they have not received any minimally qualified applicants. So there is no delay. There is no audit. If things go without any kind of a delay, you're looking at least 2 years. And unfortunately, that is the timeline we are seeing. And if there's an audit, you can even expect at least 2.5 years right now.
2.5 years is a long time, but thank you so much, Chand, for telling us about that, because timelines are very important, because we need to plan much ahead of time and know how much time we have in hand, so as to get our permit to get into the US, rather, I would say. So thank you, Chand, for saying that. And now we also have Fawad. Hi, Fawad. Thank you so much for joining us here on YouTube. So I will take up Fawad's question as well. He's asking if there are significant delays in my perm application. Should I be concerned about potential impacts on my visa status, especially if I'm already in the US on a non immigrant visa?
So if you're non-immigrant visa, such as, for example, H1 or L1, for example, you those visas are not impacted because you work under the terms of your H1B visa or your L1, or say you're working under OPT or STEM OPT, you're working under that particular visa class. So in terms of H1, for example, if you have an extension coming along, normally what you would do is you have the premium processing option. So at least on the H1B side, on the USCIS side, a lot of applications have premium processing. OPT, STEM OPT, they have premium processing. L1 has premium processing. H1 has premium processing. So at least on the USCIS side, worst case, you have an option. You have an option of getting things done in premium processing and moving along. Unfortunately, perm is with Department of Labor, and Department of Labor, the first thing is Department of Labor does not charge anything. So the perm application is entirely free. The government does not charge you anything. So that is the good thing. But again, the flip side is, because it is not funded by the fees, things take time. And that also means that you don't have premium processing. So perm does not have premium processing. So unfortunately, perm does not have premium processing, but USCIS filings, a lot of them have premium processing. The only time you will have to be concerned is sometimes the H1B and green card, they're interconnected, because H1B is only for 6 years. So if you are at a point where you're hitting the 6 year mark, you don't have the perm processed yet, yes, then you have to be concerned, because you do not get extensions beyond 6 year if a perm is not done. So if you're one of those cases where your H1B is dependent upon the perm because of the 6 year limitation, then yes, it is a problem, which is why I always ask the employer to start this process as quickly as possible. But if you are not one of those cases where you're not really worried about the 6 year mark, then I would not be worried. Then, because the non immigrant visa classes, they more than likely have a premium processing option, then you don't have to worry much about it.
Okay, so we just have to wait no matter what, even if it's 2 years. Well, that is very, very long, and you never know, it may get longer, but let's hope not. And best thing is that, we will get to know, right? Will the visa, bulletin also say about perm application by any chance? I mean, we do have for family based and employment based categories, but does can we ever know about that from the visa bulletin?
So the visa bulletin is more about the priority dates. So they're always talking about the old priority dates. For example, for India, they're talking about the 2013 dates getting current. It is more of a
Mhm.
Department of State thing, visa bulletin. Perm is
Okay.
more of a Department of Labor thing. So it's more on Department
Okay.
of Labor thing. And then when you go to the green card, such as 485s or I-140s, that is more on Department of Homeland Security, USCIS, that
Yes.
side. There are like
All different
multiple US
departments.
departments involved.
Right, right. So we cannot know this beforehand, or we cannot predict beforehand, right? What's going to happen?
Yeah, with the perms, it is hard because it depends on the volume. It also depends on market conditions, layoffs, and so on. So perm is a
Mhm.
little bit hard to predict. I mean,
Okay.
again, things were not this bad before 2020. We used to see perm approvals in 4 to 5 months at one point of time. At one point of time, we used to see around 7 months of time. Whatever we are seeing right now, 16 to 17 months, I've never seen that before 2020, at least in the past, usually. So in the last 2 years, definitely things are a little bit bad, and I don't think it is because of the new administration, because this slowness did not start now. Even last year, we were seeing extreme delays. So I think this typically started in the last 2 years. Ever since
Mhm.
DOL shifted to this new system, the new flag system, that is when we
Yeah.
really started seeing delays. So this is something that has been ongoing for the last 2 years. Hopefully, I think we have to hope that things will get better, because things were not this time taking a couple of years back.
Correct. Correct. So thank you so much. That was very insightful, Chand. And why I asked about prediction, because we very frequently get questions: when will I get my visa, or when will I get my perm, or when can I expect? my interview dates, so many things, right? And it's very hard to predict. So thank you so much for that. And we do have more questions and more people join us. So I think Saeed Ali says yes. So yes, and thank you so much to you two for joining us here at Immigration Talk Show. If you haven't as yet subscribed, don't forget to subscribe to our channel, like and share with your friends and folks who will benefit with our content. And he also said all okay or all okay. I'm really trying to figure out, but thank you. If you have any question, please feel free to comment your question. And then we also have Ling Aya. What is the current year and month for green card processing for India?
So India is the most heavily retrogressed country. So anybody that is not from India, their dates are like way ahead of India. And India, again, we're talking about two categories: EB2, EB3. So both EB2 and EB3, we're looking at early 2013. So 2013 April is where EB3 is at, and EB2 is a little bit behind. So anybody that had their perm applications filed in 2013, they are seeing their green cards. EB3 is a little ahead. And if you see what's going on for the last 1 year, last 2 years, India has been stuck at 2012 and 2013. So for the last 2 years, that's where we are. And even in the next 5, 6 months, I think we'll still be in 2013. Unfortunately, there is a lot of demand for India. And the reason for that is there are a lot of people who are born in India in the queue. And the way this visa bulletin works is it looks at the country of birth. So people get their green card based on their country of birth. And because we have a lot of people from India who have had their perm filings done, who are in the queue, so India is heavily backlogged. So right now, early 2013 is where things are.
Okay, okay. He was also asking for EB2 if you have anything for him.
So EB2 again is 2013, early 2013. And if you look at the predictions, again, we have to look at two charts. The chart number one, which is the final action chart, which is early 2013. And then you have to look at the data filing chart. And even the data filing chart, which is something that Department of State predicts what would happen after 1 year, even that is still stuck in the middle of 2013. So in the next couple of months, it's going to stay stuck at 2013. And the only silver lining is in October, once the October visa bulletin hits, you will see a little bit of a jump, because the October visa bulletin is where the next year's quota can be used. And October bulletin is where you'll see things a little bit moving ahead. But at least until October 2025 visa bulletin, you can expect things for EB2 to stay in 2013, in the early months of 2013.
All right. He's saying thanks for info, Chan. So thank you so much, Lingaya Rao, for joining us with your questions and all the best. Okay, we also have Satish. We will take up your questions. Satish, please stay with us. But for now, Chand, I really want to know why is the perm application taking such a long time? What is the reason?
Yeah. So the first and foremost reason, I think, is because the system got changed to flag from PLC. So what happened is, when the system got changed from PLC to flag, the old PLC had a different application, and in the new flag, they added a couple more things. I mean, again, they have not made any regulatory changes, but in terms of the questions being asked, in terms of the way they were asking questions, a lot of things have changed. And the way they interconnected the prevailing wages to the way it comes into the perm application, a few things got changed. And that is where we first started seeing delays. And not only that, in recent times, I would say in the last 1 year or so, what has happened is there was a lot of hiring during COVID time. 2021, 2022 saw a lot of hiring. And what that meant is, recently we have seen a surge in perm filing. So in the in 2024, late 2023, there was a surge in perm filings. So we are seeing more number of perms getting filed because economy did really good right after COVID. Because right after COVID, there was a lot of demand for employees, uh, and that all contributes to more perm filings. So that was another reason. And another big reason is layoffs in key industries. So the whole idea of perm is, you do a labor market test, you make sure there is nobody qualified in US, only then you can file the perm. So when you start having layoffs, again, in 2024 is when, I think 2023 and 2024, we started hearing about the tech layoffs. So a lot of people got hired right after COVID. Some companies realized that they were overhired, And late 2023, probably more in the 2024 onwards, we started seeing layoffs, hearing about a lot of layoffs. Big companies, Google, Microsoft, Facebook, they all started talking about layoffs. Amazon. So normally when you see layoffs in key industries, and when we talk about key industry, we're talking about IT, tech sector. Reason is a lot of perm filings come from the tech industry, the tech sector. So when you see layoffs in tech in the key industries, usually what that means is there is a possibility that there are more laid off US workers that are available for a job. And this complicates the perm process, both from employer perspective, both from the government's perspective, because employer now has to go through more resumes. They really have to make sure that there is no minimally qualified US employees. They start getting more resumes. So complicates the process on their side because they have a regulatory burden to ensure that nobody is qualified even minimally before they can even file the perm. The same thing happens on the DOL side. On the DOL side, again, they have to make sure all these checks are done, make sure there is no minimally qualified US worker. Complicates, in the end, it complicates and prolongs the perm process. So that's a big thing. And also the resourcing constraints. So we're also hearing about the DOL facing the resourcing constraints, staffing shortages, staffing limitations. So all of this will limit the processing speed. And not only that, so the perm process, the government does not charge any fee. So USCIS, every application for USCIS typically has a filing fee. For example, the H1B filing fee. The H1B runs into thousands of dollars. The government charges thousands of dollars for H1B, thousands of dollars for L1, and so on. But when it comes to DOL, when you're talking about perm, the government does not charge any fee. And what that means is DOL does not get that luxury of the filing fee, which means they are not funded by these filing fees. So that again translates to staffing and resourcing limitations. So that's also another big reason. And not only that, whenever we're talking about a lot of tech layoffs, a lot of tech workers looking for a job, local tech workers, always there's going to be increased scrutiny. Always you'll have more audits because that is what the government is supposed to do, which is why even the employers, they have a huge burden to ensure that they're looking and monitoring each and every resume to ensure nobody is minimally qualified. Because if the employer does not do things the right way, they're going to get an audit, and that will entirely lead to more processing time. So all these reasons are what is contributing to these delays.
Very interesting. And I think we will just have to be patient, friends, especially when it comes to perm. I think patience is virtue. So be very patient, be ready for anything that's going to be thrown at you, and all the best. So, also now we have more questions. And actually, yes, Chand, if you can also tell us, my next question to you, and that is, how are perm and H1B interconnected?
Sure. So usually when we talk about a perm, we're talking about the green card process. So a process where somebody is trying to get a green card and the employer wants to hire somebody on a permanent basis, not on a temporary visa. So the company is starting the perm process for the green card. When we talk about H1B, we're talking about a short term, a temporary work visa. So it is a non-immigrant visa where somebody comes into the country and can work as per the terms of H1B for that particular duration of time. So there are limitations on what somebody can do, what kind of work somebody can do, where is somebody allowed to work from. So there are so many limitations on H1B. Everybody involved, which is basically the employer, the employee, they have to make sure the terms of H1B are followed. So that leads to a lot of restrictions. The wages that can be paid, they have to follow the regulations. The location of work, the title, the job duties. So there are so many things. You cannot have material changes. And when you have that, and even the employee, you have so much restrictions. You can only work on H1B only for 6 years. That is the limit. If you have to work for more than 6 years, there are things that the employer has to proactively do or employee has to proactively do. And that is where the interconnection starts. So the rule is if somebody is on a work visa such as H1B, there is a time limit. Each time somebody gets a H1B, it is a max of 3 years. But the entire duration of H1B for somebody is only 6 years. So after 6 years, if somebody is in the country for 6 years on H1B, they have to leave the country. Usually, the usual rule is you have to leave the country because H1B cannot be extended after 6 years, usually. Now, there is a caveat. If somebody has I-140 or a perm application and they're at a certain stage, if that is the case, if it is in a certain stage of the process, then the employer can extend the H1B and ask for extension. So the rule is the perm has to be pending for at least 1 year. That is one rule. Or the second rule is they should have an I-140 approved. And when you're talking about EB2 and EB3, the only way I-140 is typically approved, typically, is if they have a perm certified, and then the employer applies for I-140 using the certified perm as the basis. So what this eventually boils down to is, if the employee's perm process has not started, then there is a good chance that their H1B might not be extended after 6 years. So for this reason, anybody that's on H1B typically has to make sure they either have an I-140 approved or their perm is at a certain stage. And for that reason, perm is very, very heavily connected with H1B, because people who are in H1B, they're contributing to the economy, they're contributing to the success of the employer they're working for. And they're doing so many things that are highly specialized. So at the end of 6 years, you don't want to leave everything and go back. And majority of the people on H1B, they do have an immigrant intent, because H1B is a dual intent visa. But to extend your H1B, you have to go through the perm process. At least majority of the people have to go through the perm process, which is why they're heavily interconnected. And not only that, people should understand that the perm process is taking a very, very long time. So if somebody waits until the last year, fifth year, their employer has not even started their perm, more than likely their perm is not going to be complete. They might have to leave the country. So there are some nuances on what exactly needs to happen and so on about this entire perm process. So employees or employers, you have to make sure, if you want to keep your employee working for you after 6 years on H1B, you have to understand that perm is a very, very important process. The government is taking a very long time, and act accordingly.
Absolutely, yes. And it's very important to follow the laws and keep all of your documents up to date. I think this goes to each and every migrant here living in the US. So make sure that you have everything. And recently, we also have the real ID thing, which we really need to make sure of. So make sure that you have an ID with the star mark on it. And to get to know more, definitely go check out our space here on Immigration Talk Show. We also had a short discussion yesterday on daily immigration dose with my co-host Sam. So yes, subscribe to our channel. Our handle is at Immigration Talk Show. So thank you. Yes, Chand, very important. H1B is one of the most famous and one of the go-to visas. I think we get a lot of questions from our folks out there with regard to H1B visa. So thank you, and also friends, if you need guidance on your status on your visa application or anything you want to consult with your immigration, yes, friends, you can contact Attorney Chand Parvathaneni and go check out this link which you can see on the screen, and yes, get in touch with him. So I think Saeed, you have some questions, or any one of you, if you have your questions, please feel free to also join us on call. You can see the number here above the screen. The number is 425-436-6335, and the access code is 988888. So feel free to join us. And yes, now Chand, if you can also tell us briefly, about this next question that I have for you, and that is, if an employer or attorney, can do anything to proactively reduce delays in the perm process.
Sure. So in terms of attorney and the company working together, the first and the foremost thing is the prevailing wage. So they have to make sure the prevailing wage is filed as soon as possible. Sometimes if the employer knows that they're about to hire somebody and they want somebody to stay in that role for a long time, a lot of employers, what they do is they proactively file for prevailing wage for the position that they know they're going to recruit, and get things ready, so well ahead of time. And not only that, the prevailing wage has to be very, very carefully be filed, because if there is any issue with a prevailing wage, sometimes you get something called RFI. So you might get a question on your prevailing wage. Sometimes that could delay the process. Or sometimes down the line, if you realize that a major mistake has been made in the requirements for your prevailing wage, that would entirely slow down the process. So the first thing is prevailing wage. File it as early as possible. A lot of employers try to proactively file for prevailing wages for the positions they know they're going to hire well ahead of time. So that way, they're always ready for their positions. And the next most important thing is recruiting. A lot of times, what we see is there are a lot of places that recruiting steps have to be undertaken. And what that means is employer has to advertise in the newspaper, advertise in the work order, the state agency work, the website. maybe advertise in their website, maybe. And there are so many places where these advertisements have to be done. A lot of employers, sometimes what they do is, because there are so many places to advertise, sometimes they forget one location or one of the advertising requirements. After their entire recruitment, they realize that they have not advertised at a certain place. So the things that employers and attorneys working together can ensure is, make sure all the recruitment steps are undertaken simultaneously. Don't wait till one advertising step is done to start the other advertising step. Start everything at the same time. If you do everything right, in 30 days you can get it done. A lot of times the reason we see delays is because employers sometimes do things sequentially. They advertise in one place, then they started advertising in another place. So slowly they do step by step. And the easiest way is, do all advertisements at once, in one shot. Get all the advertisements out, get them completed. So that way, you're not waiting for one advertisement to finish before that other advertisement starts. So that is where, being very, very cautious, you can make sure advertisements are done right. And then immediately, once you get any resume, immediately start reviewing it. A lot of times what we see is, sometimes employers get resumes, they wait until the entire process, they don't finish their mandatory review of their resumes and doing all their recruiting steps. Because if anybody is even minimally qualified, the employee does, the person who's applied for a job, they don't have to be an expert, they just need to be minimally qualified. So if they get a resume that somebody is minimally qualified, if the employer does not finish their interview process, do not ensure they do all the steps required, then they're going to slow the process down. So this recruiting is a complex step, but if things are done right, things are done very, very diligently, you can get it done in the entire 30 days. Wait for the 30-day cooling off period, and in 60 days you can go and file the perm. Another thing is, if you make a mistake in perm, the problem with Department of Labor is, they don't come back quickly. After a year, after 16, 17 months, they come back and simply reject the perm or simply give an audit. So the biggest problem with a perm application is, if you don't catch a mistake early, you wait till the last minute, it's too late. You have to redo the entire perm again. The DOL does not allow for mistakes to be corrected. So if you make a mistake in your perm application, you cannot go back and ask for DOL to correct it. A lot of times your perm is wasted. You again have to refile the perm. So what that means is, at the prevailing wage step, at the recruiting step, at the perm filing step, be extremely cautious, because it is not something like DOL will give you something like an RFE that USCIS gives you a chance to correct. No, DOL does not do it that way. They'll simply deny the perm, simply ask you to refile. They'll not let you make any changes. Changes like, if you make a mistake with offered wage, for example, mistake with the recruiting dates, mistake with maybe say the newspaper name. So all these kinds of mistakes, sometimes it's a mistake you probably can go back and say, hey, this is the correct answer. But DOL does not give you that chance. They'll simply deny the perm. They'll not let you correct mistakes. They'll ask you to refile the perm. So what that means is, being very, very diligent at each and every step is extremely important, because you don't want to wait for 2 years and then realize that you have to redo the entire perm again. So that is pretty much being very diligent at each and every step is pretty much the only way to make sure things are as quick as possible within what they can do, and ensure they're not seeing any surprises at the end of this entire 1 or 2 years.
Right, right. Thank you so much, Chand, for that. It was very, very insightful so far. I mean, getting to learn so much and, somehow preparing ourselves. So I'm really hoping that all you folks out there are resonating and are connecting here with what Attorney Chand is sharing with us today, especially with the perm process and the whole application. So don't forget to subscribe to us. Our handle is at Immigration Talk Show. And also, in case you want to contact with Attorney Chand Parvathaneni, go check out this link below. And yes, check him out, Attorney Chand Parvathaneni from Dallas, Texas, SPP Law Firm. So also, I'm so excited, Chand, that we have more people out there asking questions on our, Facebook group. So we will address to them now. And Control, please display our first question from Facebook. So, okay, this is from our community asking, if I apply for EB3 Unskilled category now, how long does it take for approval? Any approximate time?
Sure. So EB3 unskilled category is for people who don't have a professional degree, don't have a master's degree, who have less than certain experience. EB3 unskilled workers typically takes a longer time. And the way it works is, for anybody, you just go to the visa bulletin and under visa bulletin it keeps changing every time, every month. It depends on the country of birth, and you have to look at the chart and see what your country of birth is, and based on that you will have to get your the timeline. So you look at your priority date, and your company will issue, I mean, based on the perm filing, you'll be able to know your priority date. Look at the visa bulletin under the country of birth for your country of birth, or rest of the world if you are under rest of the world category. Based on that, you'll be able to see what your timeline is right now.
Yes, and everybody wants to know only about time. They want predictions on, what is going to happen, or, whichever application, visa application, perm, I-140, and it's only obvious this one also. So thank you so much. Now I got this next question on the screen. So this is control if you can display our next question from Facebook. This is from an anonymous member asking, "Hello everyone. I have been studying MBA and currently MSIT. I am looking for a job. Luck hasn't been with me. I even got foot soring. I wonder if I take unskilled job, will this impact my current MSIT education? Do I need to change any status or anything? What are the requirements for unskilled EB3? If two employers sponsor both skilled EB3 um, and unskilled EB3, is it possible?"
Sure, sure. If somebody is on F1 program, or somebody's on OPT, you typically cannot take up an unskilled job. So if you're on, I'm assuming you're on F1 visa. If you're on F1 visa and you want to take up an unskilled job, that a job that is not relevant to your education, the only way you can do it is if you're on campus. So on campus, you can do a job for a max of 20 hours while you're on F1 visa. So if you're talking about an on-campus job that you're working for 20 hours or less, unskilled jobs are permitted. But if you're talking about OPT employment, if you're talking about STEM OPT employment, for example, you cannot take up an unskilled job, and it has to be a job that is relevant to your degree. And when you talk about the EB3 process, the EB3 unskilled process, so if you have less than 2 years of experience, you're taking up an unskilled job. And say when you're talking about an unskilled job, maybe you're working, just to give an example, maybe say you're working in a restaurant in some capacity. You don't require experience for that job. The employer can still file for you under EB3 unskilled. But the way it works is the company has to again define the job requirement for that unskilled job, has to advertise, has to go through the entire perm process. And if the perm gets certified, you will be able to file for your green card under EB3 unskilled category. The EB3 unskilled is basically you have less than 2 years of experience, degree is not relevant. But again, you still have to go through the perm process because there are some unskilled jobs where there is a shortage, and that is why you have this EB3 unskilled program. So if your employer has a requirement for an unskilled job, you don't really require skill, don't really require experience, but the employer, because they're not able to find somebody locally, they're going through the entire perm process. They prove that they're not able to find workers, US workers in that unskilled category. So like a restaurant job, for example, if they go through the process, yes, you will be eligible for EB3 unskilled. The only problem is EB3 unskilled, the dates are a lot back. I mean, they're not as good as the regular EB3 professional category or the skilled worker category. But again, the employer can do this perm processing. And if you are willing to wait till your dates are current, EB3 unskilled is an option. It is an option for some countries because some countries don't have a lot of backlog. And if you're born in a country which does not have a lot of backlog, you might be able to use EB3 unskilled. Just wait until the dates are current, and then you'll be able to get the green card through that process.
Okay, okay. Thank you, Chan, for taking that up. And now let's go on to our next question. This is also from our Facebook group. Another anonymous member asking, "Hello, do you have a recommended lawyer for an EB3 unskilled visa case?" Well, I think yes, you should definitely go check out attorney Chan Pravathaneni, get in touch with him. And there's this link below where you can go click and reach out to him.
And also, what I would recommend is always check with your employer and see if they have an immigration lawyer. Because normally, if your employer already has an immigration lawyer, you're already getting they're getting some immigration work done by them. Typically, that would be the fastest way because normally that particular attorney who's working with that employer already more than likely knows about their process. So you can get things done a lot faster because the employer and that law firm already has a relationship. So EB3
Mhm.
Unskilled, again, you have to go through the perm. So always check with your employer and see if they have an immigration lawyer that they have worked with in the past. And to me, that would be the fastest to get things moving a lot quicker than trying to like vet a new law firm and hire a new law firm in general.
Okay. Thank you so much, Chan. Yes, makes sense what you just said. Now let's go on to our next one. This is also an anonymous member asking, my PD is September 2023. I just finished I-140. How many years will it take for me to get? I'm Albanian.
Sure. So I think the country I think is very important. So he's from Albania. So what that means is he comes under the rest of the world category. So rest of the world is typically a lot faster. I'm not sure which category he's from. He might be from EB1, EB2, or EB3 because that will make a lot of difference. That being said, even if it is one of these three categories, I think things will be a little bit faster. Again, so normally what happens is once you have the October visa bulletin, the dates will jump a lot ahead, typically for rest of the world category. So if it is
Mhm.
2023, depending on his category, I think you might see a lot of progress by the time you see the October bulletin. The fact that you're from rest of the world, 2023, so you're already looking at about 2 years by the time the October visa bulletin hits. So I think you relatively have a good chance in the next year or so. That being said, your category makes a lot of difference. Definitely monitor the visa bulletins. More than likely, the October visa bulletin might bring some good luck to you. Again, that's based on your category, whether it is EB1, EB2, or EB3.
Yes, very important. So, thank you, Chand, for taking that up as well. Now, let's go on to our next one. This is also from an anonymous member asking, are there anyone submitted I-140 around 2 months ago and have not got a receipt number yet? Thank you.
That doesn't look normal. So normally what happens is people submit I-140 in two ways. One, you go through premium processing. If you do it through premium processing, I would say two, 2 to 3 days to get the receipt. And if you do it in regular process, normally I see anywhere between 1 week to maybe 2 to 3 weeks, max about a month. I've never seen 2 months, so 2 months looks extreme. And normally, what you would do is, if you're submitting it through regular process, you submit it to the logbox. And when you submit it to the logbox, if in 30 days you're not getting a receipt, employer will be able to contact the logbox. So that is one way. The other way is ask your employer to see if the check has been deducted because you have to pay USCIS fees. And if the check is deducted, you know that they have received the file. And if the check is deducted, you go to the bank, you download the check, you look at back of the check. On back of the check, normally on the image, what they do is they stamp the receipt number. So looking at the check image in the bank account of the employer, that's also another way to find out if your I-140 has been receipted. And the third option is your employer can always call USCIS and inquire. And on the phone, they'll be able to say the receipt number. Okay. So the 2 months looks definitely something doesn't look right. The max I would say is a month. After a month, you should definitely, employer should reach out to the to USCIS or the logbox.
Okay, okay. Thank you, Chand, for taking that up. And also, I think we have completed our Facebook questions from our groups. Thank you so much, Control, for displaying them. And now, I also have Shalini join us. So let's take up Shalini's question asking, any approvals received for anybody selected in fiscal year 2026 H1B lottery?
Yes, yes. Approvals have already started, and people have been filing since April. So since April, people have started filing. And in terms of just the burden of proof or how what's going on and so on, things are again. I mean, not. I mean, we're not seeing any major issues. The only
Mhm.
things that I've seen is starting from January now, the employer does have to prove the nature of the assignment, and what that means is employers do have to show either the purchase order, either uh, the statement of work, maybe the client letter, maybe the vendor letter. So they do have the burden to show the documents that show what is exactly the nature of the project. So that's a little bit more added burden. But again, employers normally they're willing to provide it. It could take some time because sometimes there's a lot more additional paperwork that is involved. But if you show proof of your assignment, we're not seeing any major challenges. One RFE that we have recently started seeing lately is an RFE talking about adverse information that started last month. Now, instead of adverse information RFE, we are straight away seeing RFEs talking about biometrics. They're simply saying The employee has been sent a biometrics notice. Make sure the biometrics is done, fingerprinting is done, then come back and let us know. And what has happened is last month we have seen issues with students, and so with the H1Bs, if anybody has any kind of a criminal infraction, they can expect to see biometrics. What that means to all of you is people have to comply with the laws. If you run into any issue with the law, you do something wrong, like driving drunk, shoplifting, anything, USCIS is going to come and could cause a problem. So the bottom line: be cautious. Do not do anything that is not legally allowed. Be
Yes.
compliant, because we have started seeing RFEs for biometrics. And when you talk to people, why are you getting these RFEs? I think there's a few RFEs, but again, everybody had some brushing with the law, maybe shoplifting, maybe DUI, maybe something. So again, a reminder that people have to comply with the laws of the land. You cannot take any chances. No crime is a small crime. Crime is a crime. Violation is a violation. Be cautious. Doing so, you will avoid any kind of an issue with USCIS.
For sure, for sure. Yes, thank you so much. Those were very, very important points to keep in mind, friends. And yes, abide by the rules and never ever drink and drive. It's dangerous not just for you, but for everybody else on the road as well. So take care of that. And don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. And hit that bell icon so that whenever we have discussions like these, you're also notified. And it's been amazing so far, Chand. I also would like you to tell us about some of the most common mistakes, that people, make while filing for a perm application, which could further delay the whole process.
So the biggest mistake that people make is they wait too long, because I mean, we see a lot of people who are working on OPT and STEM OPT. Their employers are ready to kind of start their green card process, because the employers are like very happy with somebody's work. They want to keep them long term. They want to sponsor for their green card process. So we have seen a lot of cases where their perm application starts when somebody is on F1. And we even had cases where their 485 was filed when um, uh, their status was F1, because their employer did the perm application. Employer wanted to sponsor them for long-term residence, permanent residence, and at that time they were on F1. You file the 485, and things get rolling in. So the bottom line is, people don't really have to wait years and years and years. If you're doing a good job and your employer is satisfied with your work, and you want to work in United States for a long time, or you want to like immigrate to United States, talk to your employer, ask them to get the perm process started. Maybe you're in the first year of perm, second year of perm, maybe it doesn't matter. The perm can start at any point of time when employer is ready to start your green card process. So talk to your employer. If you think that employer is satisfied with your job, talk to them about perm sponsorship, because you don't want to wait until the last minute because of the 6 year limitation on H1B, and then realize perm is taking a very, very long time. Because sometimes there are audits in perm, sometimes there are denials in perm, sometimes there are denials at 140 stage. So don't wait until the last minute. Get this process started as early as possible. If you're working on STEM OPT, you know that you're contributing a lot to your employer, and your employer is very happy with your work. Get the conversation started, conversation about the perm. Or you're in the first year of your H1B, get the conversation started. Uh, because a lot of people think that you have to wait until the fourth year or fifth year of your H1B to start the perm process. No, things can get started. And that is what I think everybody should understand, and get this process started as early as possible. And doing so, you will see less challenges and less surprises. And not only that, from an employer perspective, be very, very diligent. There are very complex rules about perm, things like where you should advertise, what is the wage offered, how you should do the recruiting. There is an important requirement called minimally qualified applicant. So the company also has a burden. So overall, everybody start this process as early as possible. Uh, the sooner things will be done, and the lesser surprises you will have. So that's the message I want to give to everybody. Get your process started as early as possible. Do not wait until the very late stages of your H1B and then realize that you have to leave the country because your perm is not done, or your I-140 is not approved.
Right, right. I mean, there's this habit of procrastinations that some people have, and they really leave it till the end of the time. So let's not do that. I mean, especially with regard to your visa application or any of the process like perm. So all the best to each one of you. Thank you so much for joining us here. It was Wonderful having each one of you and your questions as well. So if you haven't as yet subscribed, please do subscribe and also like, share our content with your friends and folks out there who will benefit most from these free, how to say, very, very beneficial webinars, very insightful webinars, so much information that you wouldn't want to miss out on. And Chand, it was lovely having you once again. Really, it's always nice to have you because you really enlighten us with so much important information, and it's always great to have you.
Thank you so much.
So, anything else you want to tell people out there who are watching us right now before we leave, or any important case that comes to your mind, especially today that we spoke about perm application?
Sure. So in terms of perm application, again, so we had seen a lot of cases in the last couple of months where they were in the sixth year. The perm is taking a very, very long time because a couple of years back, people did not realize that perm was going to take so long. And we had a couple of cases recently. So one of the things is if the perm is pending for at least more than a year. So we recently had a case, the perm was not approved. And I would say like a couple of cases, not one or two. We had a couple more than that where the perm was not certified. The employees in the sixth year, they were about to file for an extension. The perm has not been approved yet. So, I mean, before I leave everybody, I want to give like two concepts. There is a concept called recapture of time, which means if somebody goes out of the country during the 6 year H1B period, anytime they're not in the country, you can recapture that time and you can add that time to your H1B to extend your H1B. So there is this important concept called recapture of time to add to your 6 year period. So some people might be able to take advantage of that. There is also another rule. If the perm is pending for more than a year, no fault of anybody. So for example, right now, perm is taking 16, 17 months. So if the perm is filed, the perm is not approved, but it is pending for at least 1 year or more. In that case also, somebody can file for an extension. The only problem is you can only ask for 1 year of extension after sixth year. But if somebody's perm is filed, the perm is not getting approved, the perm is still pending for at least 12 months. You still might be able to get an extension for 1 year. So that's another thing that could help somebody because people think if a perm is not approved, they have to leave the country. But the rule is if the perm is pending for at least 12 months, you would be able to use that reason to ask for 1 year of extension. So these two things are something that I think people should know if they are in the bad situation where they are in the sixth year, perm is not approved, and they probably have some recapture time.
There you go. That was important, and that's a good tip, I think, because of course, 6 years is a long time, and I'm sure that people go out for travel or maybe meeting the family for a couple of months at least, and that could benefit you, especially when you need it. And thank you, Chand. And quickly before we leave, we'll address to Rao's last question for today, I think, and this is about FDNS site visits. So, client will not share any letters to contractors. They won't support client site visits for contractors on FDNS visit. So, is USCIS will do FDNS visits or verification at employer? He's asking if USCIS will
Yeah.
do this.
So usually the FDNS visits most of the time they happen at the work site. So whatever is the work site that is mentioned on your I-129, that is where the site visits happen. So in your case, for example, if your work site is like say remote work from home or from your employer, that is where the FDNS site visit happens. But if the work site is at your client, USCIS officer could potentially go to the client location, and we have seen a number of instances where they go approach the client office and say they want to do a site visit. That being said, if there's a genuine case where there is some problem where the client is not verifying, the officer might still give you a chance to show other evidences, maybe evidences such as your emails, such as your pay statements, such as the vendor contracts. So it is not that sometimes if the client says absolutely no, USS officer, that is the end of the process. No. Uh, Again, I've seen USS officers use other evidences because all they're trying to confirm is, are you working as per the terms of the LCA? So if you have other ways to prove it, the officer might be happy. So if the USS officer say visits your client location and say you are in the client location, you come out of the office, they see you coming out of the office, provide other evidences that will prove that you're working as per the terms of your LCA and so on. You might be okay with it. Okay, so again, from your employer perspective and from your perspective, the site visit is mandatory now with the new rules. So you do have to kind of participate in the site visit, do provide information to the
Yes.
extent that is required to prove that you're complying with the LCA requirement. from a client perspective, yes, there could be problems because third party is not under your control. And but again, as long as you're able to prove through preponderance of evidence, that means more than likely or not that yes, you are complying with the rules. If you're able to prove that, you should be okay.
Okay. Thank you so much. That was very important, and all the best to Rao out there. Thank you for participating with your questions, and all the best. Thank you, Chand. Really, having you was great today. And friends, if you want to contact Attorney Chand Parvataneni, do check him out on his this link, which is provided on the screen. And yes, get in touch with him, and don't forget to let him know that you saw Attorney Chand here on Immigration Talk Show, and he'll be really happy to help you out. So thank you, Chand, once again. Really happy to have you, and I hope to see you again maybe in the coming week.
Thank you so much, Nipasa. Yeah, bye bye.
Bye bye. So, once again, friends, subscribe to our channel. Our handle is at Immigration Talk Show. We are not just here on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. So, follow us, stay connected with us, and also you can contact me in case you have more questions, for attorneys out there or anything related to US immigration. Please feel free to also contact me. This is also my WhatsApp number. My number is 408-335-6444, and my email address is nipa@staffingme.com. So this is it for now, but stay tuned here on Immigration Talk Show because there's more coming and so much information that you do not want to miss. Bye for now.